from undertaking any processes required under Article 257, 4, and 5 of the Constitution. Obviously, this order equally was not appealed by the AG, neither by the IBC. It therefore means that processes under Article 257, 4, and 5 cannot be undertaken and should not be undertaken by the IBC in the absence of an existing legal and regulatory framework to guide those processes. So the question therefore would be, why is Muhuri here? Muhuri is here because in its appeal, the AG is aggrieved with the finding that was made, in particular that the BBI bill contravened Article 10 of the Constitution on public participation. On its part, IBC appeals the findings that were made that touch on composition and quorum of the IBC. To that end, therefore, I will address this court on two issues. The first issue would be the interpretation of Article 88 and 250 in respect of composition and quorum of the IBC. And number two, what would be the mandate of IBC under Article 257, 4 of the Constitution. I now move on to the first issue, which is on the quorum of the IBC. To that end, two important findings were made by the Court of Appeal. The first one was that IBC was not quorate at the time it verified and certified the BBI bill under Article 257, 4 and 5. And the second one was that the IBC was not quorate at the time it developed the administrative procedures that it used to undertake and guide the verification of signatures. We have been told by the IBC that the composition of IBC ought to be 3 members as stipulated in Article 250 of the Constitution, and not as set out in the second schedule to the IBC Act. In this court, IBC further contends that the Superior Court judges disregarded the decision that was made in the Isaiah Kibiwott case. That is where we start our submissions. We submit to say that contrary to the position that has been made to this court, that the court disregarded the applicability of the Isaiah Kibiwott case, we submit that indeed both the High Court and the Court of Appeal considered in length the application of the Isaiah Kibiwott case. And in 2 cases, both courts held that the obligation of the IBC under Article 257 and 4 and 5 of the Constitution was not an administrative exercise, but it was a very serious and heavy constitutional obligation that was placed on the IBC with very serious implications that could not and cannot be left to a 2-member majority. The question therefore at this point would be, what would happen if at all we are to agree with the submissions of the appellant that the quorum ought to be 3 and not 5? My Lord, currently the IBC has 7 members as constituted today. It therefore means that for any decision that has to be made by the 7 members of the commission, we only need 3 as part of the quorum. That would mean that in any instance, we have 2 members that are making a decision that is going to bind the commission as well as the people of Kenya, because any function and any duty the IBC undertakes is a constitutional obligation that is placed upon it and binds every person, including any Kenyan citizen. Therefore, we submit to say that it could not have been the intention of the registrators that we would have to have a 2-member majority make decisions of the IBC. Basically, that's what it means if we are to stick with a 3-member quorum. In any event, it is not also lost to us that the Isaiah Kibiwott case was not binding on the High Court at the time it was made, because it is a court of concurrent jurisdiction. Neither was it binding on the Court of Appeal. The High Court could and actually did depart from the Isaiah Kibiwott case, and it gave its reasons for doing so. The High Court gave its reasons for departing from the High Court decision in the Isaiah Kibiwott case. It stated the following reasons. Number one, the High Court stated that the IBC statute did not distinguish between policy and other business. The court, therefore, in departing from the Isaiah Kibiwott case, held that the IBC can conduct its business, cannot conduct its business when its composition is below 5. The duty that was placed before the IBC under Article 257, 4 and 5 to verify and certify that the BBI bill was supported by more than 1 million registered voters was a core business of the IBC, and therefore it required the majority, it required the requisite quorum, which would be 5. Number two, the High Court considered the question whether or not the BBI bill had met the constitutional requirement for purposes of Article 250. The question whether or not the BBI bill had met the constitutional obligation under Article 257(4) was a very serious obligation and required a number of 5. I've already said that in so doing, the High Court considered the peculiar history that we have in this country as far as it relates to electoral processes, and found that a 5-member commission would, a membership of less than 5 would not be the intention to make such decision, and that quorum was as stated in the Isaiah Kibiwott case, and it is a critical obligation that was placed on the IBC. My Lord, there has been attempts to reduce the quorum from 5 people, 5-member commission. This was done through the amendment bill, the Elections Laws Amendment Bill of 2017, which reduced the quorum from 5 to 3. That was challenged in the Katiba case, and the Katiba case challenged the constitutionality of that amendment, and the High Court found in favor of Katiba case, and it issued an order declaring that any attempt to reduce the quorum of the IBC from 5 members to 3 members was indeed unconstitutional. That was the position as at the date the IBC received the signatures supporting to amend the Constitution, the time the IBC verified those signatures, and at the time the IBC certified that indeed the BBI bill was supported by more than 1 million registered voters. The question therefore before this court, and this court must answer, is what was the effect of the declaration of the unconstitutionality that was made in the Katiba Institute case? To answer that question, I would ask the court to find guidance in the Court of Appeal decision in the case of Javan Kiche Otieno, that is in our supplementary band of authorities, which was issued on the 17th of December 2021, a few weeks ago. In that case, the Court of Appeal sat to address a similar issue on what would happen to the original provision of the law when an amendment to that law was declared unconstitutional. In that case, the Otieno case, the court held that at paragraph 46 of that decision, that the inconsistency that the court found to be that the provision, the amendment, was unconstitutional arose from the day that amendment came into force. And therefore, the provision was a nullity from that date and not the judgment date. In short, what the Court of Appeal was finding in that case was to say that the minute that amendment took effect and the court subsequently declared the amendment to be unconstitutional, the unconstitutionality does not arise on the date of the judgment, but on the date the amendment took effect. However, the court also considered the question of what would happen in the intervening period when that amendment was in force. At paragraph 47, the court answered that question, and the court found that the actions that had been taken or uncrystallized when the statute or the amendment was in force were not unconstitutional and could be salvaged and could be held in regard to that. However, most important, in regard to the particular amendment that the court was considering, the court found that once the provision was declared unconstitutional, that provision, that amendment became void from the date of the amendment or the date the amendment took effect. So therefore, we can equally do a comparative analysis. In our submissions, we have referred the court to the position in South Africa, position in Canada, on what happens when a statute has been declared unconstitutional, and I believe the court is going to consider that when it retires. However, I would like to, at this point, to refer the court to a South African Constitutional Court decision in the Vin case, where the court found that once a law has been declared to be inconsistent with the Constitution, that law ceases to have any legal consequences. That is what our own Court of Appeal is saying, that once the amendment was declared to be unconstitutional, it ceases to have any legal effect. And then the question is, therefore, what would happen to the original provision? I think that is the issue that this court would address. So once the amendment falls off, what happens? The IEBC in this court has submitted that once the amendment falls off, the original amendment, which was the subject of the amendment, is deleted or ceases or equally to have the full force of the law, meaning there would be a lacuna. There would not be any law that governs that particular provision or that particular area that has been declared unconstitutional. So the question then is, or the issue as I understand it, is not the legal effect of the declaration of invalidity, but the effect of the original provision that was the subject of the amendment. We submit that a declaration of unconstitutionality does not affect the original position of the law. Once the declaration has taken effect that the amendment is unconstitutional, then we revert status quo ante, and for a good reason, to prevent a lacuna being there in law. Therefore, in our humble submission, the provision on quorum remained in force as the governing law until either the declaration that set aside that unconstitutionality, invalidity is set aside, or a new law is enacted. However, we are very well aware that any court that sits down to determine or consider the constitutionality of a law has equal powers or has the power to grant an appropriate remedy as far as that declaration is concerned. The court may and has many other times issued prospective or retrospective application of the declaration. At this point, therefore, I will ask the court to look at the orders that were issued in the Katiba Institute case. In that case, the court issued 2 declarations on constitutional validity. It returned a verdict to say the provisions they were unconstitutional and declared them as such. The court did not move further to save that declaration. The court did not suspend the declaration. Unlike the South African Constitution that provides expressly for the power to grant an order of retrospective application or prospective application of the declaration, the Kenyan Constitution does not directly provide for such a relief. We are, however, aware and we are cautious to the fact that the Kenyan Constitution equally provides for the court to grant an appropriate remedy. We therefore submit that the order of prospective or retrospective application was not granted in the Katiba Institute. Such an order would be available right now to the appellants if it was pleaded in the Katiba case. If, even when it was not pleaded, the court granted the order as an appropriate remedy to suspend the declaration of invalidity. And therefore, because the court in that case did not suspend the retrospective or a prospective application, did not find as such, it therefore means that that order is not available in this case at this time. Because they were not granted in the Katiba Institute, this court is not sitting on review of the Katiba Institute case, neither is it sitting on appeal of that decision. So, therefore, the law today, as it is on quorum of the IEBC, is as set out at paragraph 5 of the 2nd schedule of the IEBC Act. Interesting, this provision has not been challenged in these proceedings, has been inconsistent with Article 251 of the Constitution, and therefore we urge the court to find that the 2nd schedule on the 2nd schedule to the IEBC Act on paragraph 5 that provides for the quorum of IEBC has the full legal effect and serves a legitimate purpose in a democratic society. I will now move on to the 2nd issue, which is on the mandate of the IEBC and Article 257(4) of the Constitution. Muhuri will address only one aspect of that issue, and it is on the issue of public participation on enactment of the administrative procedures. In this appeal, the IEBC contests whether it has an obligation under Article 257(4) of the Constitution to satisfy itself that the promoters of the popular initiative and conducted public participation on the BBI bill before it certifies that under Article 257(4) and 5 of the Constitution, it had been supported by more than 1 million registered voters. On this issue, we submit that, number 1, IEBC had an obligation under Article 257(4) and 5 to satisfy itself that the criteria that was established in Article 257(4) and 5 was applicable while using the existing laws and guidelines. At this point, I will refer the court to the question that was asked by the Chief Justice yesterday, when she did ask whether or not it is important to have some form of a legal framework that would guide public participation on the mandate of the IEBC and Article 257(4) and 5. We would answer that question, the Chief Justice, and say, at the time the IEBC undertook the verification and certification of signatures under Article 257(4), there was no law or any regulations that provided for the actual procedure on how the IEBC would do that, including public participation. This finding was made also both by the Court of Appeal and the High Court, and interesting, it has not been challenged in this court. Therefore, in the absence of a regulatory framework, IEBC ought to have been guided by the provisions of Article 10 of the Constitution that generally provide for the principle of public participation as a core aspect of governance in this country. The Constitution at Article 257(4) envisages a 3-month window period between which the IEBC would undertake its processes under Article 257(4). We of the view that the 3 months period would equally be used by the IEBC when undertaking the verification of signatures to grant the public sufficient time to confirm whether or not they had appealed their signatures in support of the amendment bill. Such public participation was made to look like it would be so difficult to attain. In our view, we have the view that, as it was in the administrative procedures, that the IEBC should provide a process where the public get to confirm indeed to the IEBC that if they've appended or they were in support of the bill. They should provide a window period within the 3 months period envisaged in the law for a complaint mechanism, as well as a mechanism to resolve those complaints when they arose. In the instant case, the IEBC provided in its administrative procedures that were indeed found unlawful that the public had 22 days through which to verify whether or not they were in support and had provided their signature in support of the bill. However, IEBC published the names of those people in its website and provided for 5 days period through which members of the public would indeed confirm to the IEBC whether they are in support of the bill or not, and also the 5 days period was also to be a complaint period. The question therefore is, did IEBC have a simple, accessible, and transparent processes for signature verification that would enhance public participation in the process as envisaged under Article 257(4) and 5? The answer is no. The process was not simple, how the public would get to participate and verify their signatures, because when you go to the IEBC website, and this information is on record, IEBC provided a PDF scan. One could not use or search their name or ID number on the website because it was a PDF scan. Even I, as an advocate, we had to spend voluminous time going through the list to indeed look through the list and understand what the IEBC was doing. Number two, the IEBC put this information on its website. Was that accessible to majority of Kenyans? Satisfactorily not. The website stated that the notice to make complaints would be there for 2 weeks. However, the IEBC shortened the period to 5 days. How many Kenyans have access to website and internet in this country? How many are able to go through, have internet, access it, and be able to complain to the IEBC that their names are erroneously put or they did not provide their signatures? How many? Very few can. Was it verifiable? Was it accountable? How the IEBC undertook this? in the absence of a legal framework, in the absence of lawful guidelines and regulations, even we are clear that it also breached its own administrative procedures, who was the IEBC accountable? Can we therefore say that there was public participation in the verification and certification processes as envisaged under Article 257, 4 and 5 of the Constitution? The answer would be no. On the second aspect of public participation, the question then would be, how should it look upon the verification and the certification? On this one, I agree with the submissions that was made by Mr. Ngumbo yesterday, that public participation would arise on 3 instances upon the bill being certified as being supported by 1 million registered voters. The first instance would be at the county assemblies. The county assemblies have an obligation under Article 196(1) of the Constitution to undertake public participation in its legislative mandate. So at the point it is considering the bill, of course, it is envisaged that it would use and would avail the bill for public participation. The question would be, was that done? Public participation is a factual issue. It is an issue that ought to be proven through evidence. The county assemblies are parties in this suit. Unfortunately, they did not participate in the proceedings, and therefore, being a factual issue, it is conclusively to say that there was no public participation at the county assemblies in absence of the requisite evidence. The second instance when public participation would be envisaged is at Parliament, when Parliament is considering the amendment in terms of Article 118 of the Constitution. And equally, at the very end of the process, when the IEBC is undertaking the referendum, that obligation would be in form of civic education on sensitizing the members of the public on the content of the BBI draft bill or any draft bill. We therefore submit to that end that there is a need for legal framework to guide the processes on public participation to ensure that indeed it complies with the IEBC constitutional mandate and obligation, especially while undertaking its verification, certification, and referendum processes. Such a legal framework is very important because it would make the process accountable to the law and therefore be able to ensure that it complies with the Constitution or any other legal framework. Thirdly, we submit that without a legal framework, there exist so many gaps. And one of that gaps is what the Chief Justice did identify: public participation. How is it supposed to be done? Had we had a legal framework, it would be very easy for us to go back to that legal framework and seek whether or not the IEBC complied with the law. Indeed, Chief Justice, there have been attempts made by Parliament to legislate on these processes. On record, you'll find 2 bills that are currently pending through Parliament. A casual reading of the 2 bills would provide that indeed at Section 8 and at Section 4, both of the bills provide for public participation. So there is need for a legal framework. There is need for a legal framework to guide how the IEBC undertakes its mandate under Article 257, 4 and 5 of the Constitution. Having said that, and having finished what the 2 issues are, I will therefore urge the court not to disturb the order that was issued by the Court of Appeal, Order number 14, that issued a permanent injunction restraining the IEBC from undertaking any of the processes under Article 257(4)(5). That order has not been appealed, and the issue of an existing legal framework has also not been appealed in this court. We therefore urge the court to affirm the Court of Appeal findings and we dismiss the appeals. We also associate ourselves with the submissions made by the third apparent on the issue of quorum in this court. And that will be all from us. Thank you. I will donate the remaining minutes to the 7th and the 8th respondent.